Good morning and welcome back to the High Court Report. Before we jump into today's deep dive, we've got to share the wildest procedural twist we've seen in years.
So, get this. After 5 years of legal battles, Lindsay Hecox tried to voluntarily dismiss her own landmark transgender sports case just 3 months before Supreme Court arguments. But here's the kicker. The district judge said, absolutely not, and struck down her dismissal attempt. The judge literally called it void and said it flaunts principles of equity and fairness. Imagine suing the government, winning at every level, getting to the Supreme Court, and then trying to back out at the last second.
It's like training for the Olympics for 5 years, qualifying for the team, then calling in sick on race day. The court was not having it.
But here's what makes Hecox's attempted retreat even more fascinating. She might have actually been making a smart strategic move. Think about it. When she first filed this case in 2020, Bostock was the shiny new precedent expanding transgender rights. Fast forward to 2025, and Skrmetti has completely rewritten the constitutional playbook.
Oh wow, that's actually not a bad idea if you're reading the tea leaves. She's looking at the current Supreme Court and thinking, maybe I don't want to be the test case that cements a restrictive precedent for the next 30 years.
Exactly. It's like realizing you're about to feed the beast of Skrmetti, that restrictive constitutional framework that's been devouring transgender rights claims. Sometimes the best strategy is not to fight a battle you're likely to lose spectacularly.
But the judge's reasoning was forceful. If we let Hecox walk away now, what stops another transgender athlete from filing the exact same lawsuit next week? The legal questions would stay completely unresolved, and frankly, the next plaintiff might not be as strategically savvy.
Right, because constitutional law doesn't care about your tactical preferences. These fundamental questions about equality and fairness are going to get resolved one way or another. Better to do it with a well-developed record than to start from scratch.
Which brings us to today's case, Little versus Hecox. This could reshape transgender rights and women's sports across America, and it nearly disappeared into thin air because one very smart lawyer recognized she might be walking into a constitutional buzzsaw. But here's the twist. This case is now consolidated with West Virginia versus BPJ, creating a massive constitutional showdown with oral arguments set for January 13th, 2026. And the United States will participate at oral argument. That makes up to 5 possible advocates instead of the usual 2 or 3.
The more the merrier. I really enjoy 4- and 5-party face-offs. Each party brings a new element or dimension to the arguments. Each party comes from a different viewpoint, even if they're on the same team, so the arguments become more nuanced.
I think cases with 4 and 5 advocates should have special names. Any ideas for what we should call them?
I actually queried this question to AI, Anthropic Claude, but got a little cheeky when I asked for options that the New York Post would use. Are you ready for the answers?
Probably not, but let's do it.
For 4, foreplay. Get it. Fantastic 4. For real? Forward march. For the win. Not really descriptors, but headlines. And for 5, 5 guys. Take 5. High 5 court. 5 alive. Give me 5. What's your favorite?
Claude nailed it. I love foreplay, for real, and 5 guys. Although this title could be wrong if there's a female. Listeners, let us know what we should call it. Let us know by email or LinkedIn.
Okay, return to the case because it could forever shape transgender rights and women's sports across America.
Okay, before we get any further, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn to get nearly daily rundowns, and follow on YouTube to see shorts. Just search the High Court Report, and if you have questions about this case, reach out via LinkedIn or email, scotus.cases.pod@gmail.com. We respond to every message. All right, here's what you need to know. So here's the setup. Back in 2020, Idaho passed the first law in the nation to categorically ban transgender women and girls from competing on female sports teams. Lindsay Hecox, a transgender woman at Boise State, wanted to try out for women's track and cross country.
Idaho said no way. The law draws what they call a bright biological line. Your birth certificate determines your team, period. No exceptions for hormone therapy, no individual assessments, nothing.
But here's what makes this case fascinating from a legal nerd perspective. Remember our summer episodes where we tracked how quickly the Supreme Court moved on this? They granted cert within weeks of deciding Skrmetti? That big transgender medical treatment case.
Right. And we talked about how they could have just done GVR orders, grant, vacate, and remand, basically telling lower courts, hey, reconsider this in light of our new Skrmetti decision. But they didn't. They wanted to hear these cases directly. And then we did that Bostock Bounce Back episode in August, where we predicted how this would all play out. Turns out we were pretty spot on about the strategic realignment.
For anyone just joining us, Bostock was that 2020 case where Justice Gorsuch said you can't fire someone for being gay or transgender without discriminating based on sex. Skrmetti last year basically said, hold up, that logic doesn't automatically apply to constitutional cases.
So now we've got the merits briefs, and it's exactly the battle we predicted. Idaho and the feds are weaponizing Skrmetti while completely ignoring Bostock. Hecox's team has basically retreated from Bostock's approach entirely. Let's break down what actually happened to Lindsay Hecox first, because the human story here is pretty wild. She was a high school track runner who transitioned and started hormone therapy that reduced her testosterone and muscle mass.
She met NCAA standards for women's competition at the time, so she gets to Boise State, super excited to try out for the women's teams, and boom, Idaho's new law blocks her completely. She sues, wins a preliminary injunction in 2020. The district judge found what they called a dearth of evidence, that excluding transgender women actually serves any legitimate purpose. The Ninth Circuit agrees, but here's the plot twist. Lindsay never actually makes the team anyway. She tries out but isn't fast enough, ends up playing club sports instead.
Wait, so this whole constitutional battle is over someone's right to try out for a team they ultimately wouldn't have made?
Exactly. It's like fighting for 5 years for the right to audition for American Idol, then not making it past the first round. But legally, that doesn't matter. It's about the principle and the barrier itself.
Now let's talk strategy, because this is where our Bostock bounce-back prediction really paid off. Idaho's approach is basically, Chief Justice Roberts gave us everything we need in Skrmetti. Petitioners argue that constitutional sex means biological sex only, what they call an objective trait rooted in biology, not a subjective concept based on gender identity. That's straight from the Skrmetti playbook.
And notice what they're not doing, barely mentioning Bostock at all. In our August episode, we predicted conservatives would treat Bostock like a hot potato while embracing Skrmetti. Nailed it. Idaho makes this clever argument that this isn't even traditional sex discrimination. Since Hecox doesn't challenge excluding biological males generally, just Idaho's definition of who counts as female, they say it only deserves rational basis review.
It's like saying we're not discriminating against men, we're just defining what women means. Legally sophisticated, but feels a bit slippery.
Then there's the quasi-suspect class argument. Idaho basically says, transgender people don't deserve special constitutional protection because gender identity isn't immutable, and transgender folks aren't politically powerless.
Which is interesting timing, given that 691 bills targeting transgender people were introduced across 43 states just in 2024. Doesn't exactly scream political power.
Now, Hecox's response strategy is fascinating because it completely validates our prediction about liberal retreat from Bostock. Instead of fighting that battle, they pivoted to VMI, that military school case about excluding women.
Smart move, actually. They're arguing that categorical exclusions violate equal protection regardless of how you classify them. It's like saying, even if you can separate based on sex, you can't do it categorically without individual consideration.
VMI said you can't exclude all women from military school because some women can meet the standards. Hecox argues you can't exclude all transgender women from sports because some might not have competitive advantages after hormone treatment. But here's the problem. Skrmetti gave states huge deference on medical and biological questions. Roberts might just say, states get to make these judgment calls about competitive fairness.
And then we get to the Trump administration's brief, which is where our Bostock bounce-back thesis really gets wild. They're not just embracing Skrmetti, they're going full maximalist.
The government argues that constitutional analysis provides even more deference to sex classifications than statutory interpretation. That's completely backwards from how civil rights law usually works. Think about it. Normally, the Constitution provides broader protection than regular statutes, but the government is arguing constitutional sex discrimination law is actually more permissive than Title VII employment law.
They cite Skrmetti to argue it forecloses any claim that biology-based rules are really about targeting transgender people. It's using Roberts' opinion as a constitutional ceiling, not a floor.
This answers the question we posed in our Bostock episode, whether we'd see different standards for statutory versus constitutional sex discrimination. The answer appears to be yes, with constitutional law being more restrictive.
So, what does this mean practically? Well, if you're a transgender student athlete, the constitutional protections you thought existed after Bostock might not actually be there.
And if you're a state legislature wanting to regulate sports participation, you've got a pretty clear roadmap from Skrmetti about how to write laws that will survive constitutional challenge.
The broader stakes here go way beyond sports. Employment discrimination, housing rights, educational access, all of this could get the same constitutional framework that prioritizes biological classifications over individual consideration.
It's also worth noting the federalism angle. More than half the states have passed similar laws. A Supreme Court ruling could either validate this nationwide trend or shut it down completely.
Looking ahead to oral arguments, I'm really curious how Chief Justice Roberts handles his own precedent. Does he try to distinguish sports from medical treatment, or does he stick with Skrmetti's biological framework?
Also, I'm curious to see how Justices Kavanaugh and Barrett attempt to answer their questions from Skrmetti about sports. Let's have a listen.
Based on the briefing, it seems like the Bostock methodology is basically dead for constitutional cases. Even transgender rights advocates aren't really trying to use it anymore.
The conservative justices will likely follow Roberts' lead from Skrmetti. Biological differences are real, states get deference, competitive fairness matters. The liberal justices are left arguing for individual consideration without Bostock's conceptual foundation.
Justice Sotomayor might push back hard. She fully embraced Bostock in her Skrmetti dissent, but the briefing suggests even she's facing an uphill battle against this new constitutional framework.
One thing that strikes me is how much this reflects broader cultural battles about biological sex versus gender identity. The legal arguments track pretty closely with political divides.
And the timing is crucial. We're seeing this after a massive wave of state legislation targeting transgender rights. The court's decision will either accelerate that trend or put the brakes on it.
For parents of transgender kids, this case represents whether their children get equal access to school activities. For parents of cisgender girls, it's about competitive fairness and opportunities.
Those aren't just legal abstractions. They're real families dealing with real consequences of whatever the court decides.
The other wild thing is how this case almost didn't happen because of Hecox's dismissal attempt. Imagine if all these constitutional questions just disappeared because one plaintiff changed their mind. The district judge probably saved us from years more litigation by keeping this case alive, though I'm sure Lindsay Hecox doesn't see it that way. So bottom line, our Bostock bounce-back prediction appears spot on. Skrmetti reshaped the entire constitutional landscape, and these briefs show both sides operating in that new reality.
Whether that's good or bad depends on your perspective, but it's definitely a fundamental shift in how constitutional sex discrimination law works.
We'll keep tracking this case through oral arguments and the decision. It's one of those cases that could reshape civil rights law for a generation.
That's our preview on Little versus Hecox and the constitutional battle over transgender sports rights. Thanks for listening to the High Court Report.
Questions about this case? Hit us up on LinkedIn at the High Court Report. Please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn to get nearly daily rundown, and follow on YouTube to see shorts. Just search Carre de qui? The High Court Report. Like trying to escape a $750 million state court verdict. Sometimes you need all the help you can get. Talk to you soon.